Yes, Mr McLaughlin.
My lords and my lady, I appear on behalf of the appellant, the Fourth Defendant. Mr Lemmy appears on behalf of the respondent, the Claimant. Sadly, Mr Melton of leading counsel, who also represents the claimant in this case, is unable to attend because of personal reasons.
Yes, we were very sorry to hear about this.
Yes. The second defendant is not represented on this appeal. Their solicitors have, as I understand it, received the appeal papers and were made aware permission to appeal was granted to the fourth defendant by Lord Justice Newgee on all grounds, and asked whether they wished to be made a respondent to the appeal. They did not wish to be so.
But they're not affected unless one of your submissions is correct, namely that this was a joint and several order, which on the face of the order it wasn't. It was 150 each.
Yes. The fourth defendant's appeal is against the order made against it by His Honour Judge Bird Queen's Counsel, sitting as a Section 9 judge, for an interim payment in the sum of £150,000 pursuant to CPR 25.71E. A copy of that order can be found at page 26 of the appeal bundle, which I assume my lords and my lady have seen. The factual background to this claim, and indeed the application, is set out in paragraphs 1 to 8 of the judgment on pages 90 and 91 of the appeal bundle, which again, I take it, my lords and my lady have read. I propose to take paragraphs 1 and 2A of the grounds of appeal, referred to as paragraphs, or referred to in the skeleton as grounds 1 and 2 together. The grounds of appeal are on pages 12 and 13, and they're dealt with in the skeleton at pages 18 to 22. In essence, these grounds concern the judge's conclusion that he was satisfied that if the claim went to trial, the claimant would obtain judgment against at least either the second defendant or the fourth defendant, but could not determine which. And I emphasise those words, but could not determine which meant that the first limb of subparagraph E was satisfied. I accept at the outset, ground 1 is not a freestanding ground of appeal. However, in my submission, the mistake referred to in ground 1 was what led to the error identified in the second ground. The judge dealt with this limb of subparagraph E at paragraphs 11 to 14 of his judgment on pages 91 to 92, at which I shall turn up. At the top of page 92, halfway through paragraph 11, the judge noted Mr Melton emphasised the application was made under E, and he said, "He is, in my judgment, entitled to do that, so E must be the starting place. If I was not satisfied that he applied, then it seems to me I could go back to the beginning of the rule and start again. In particular, I would no doubt be interested in subparagraph 1C. It seems to me the order of consideration is not important. Paragraph 1C and 1E cannot both be satisfied. The first applies where there is clarity as to the identity of the party against whom judgment will be entered. The second applies where there is no clarity." The judge was correct to say that subparagraphs C and E are mutually exclusive. However, I do not agree with his observation that the order of consideration is not important. Subparagraph E requires the court to be satisfied that it does not know against whom judgment will be entered. In other words, to come to a positive conclusion on what is, in essence, a negative question, the court has to ask itself, am I satisfied that I do not know which defendant will be liable? The danger of doing that before dealing with subparagraph C, in, for example, a case like this, is the court may not properly address the reasons why it cannot be satisfied the claimant will not obtain judgment against an individual defendant falling, or who is the subject of an application under E.
Could we just pause? You haven't given us in the bundle the rule itself, but we've all no doubt got access to it in one form or another. Can we focus narrowly at the moment on ground 1, although I appreciate that you regard it as being, in a sense, the portal to ground 2A. I understand that point, but you're here asserting under ground 1, as a matter of fact, that the judge should have gone to C before he went to E for the reasons that you're developing.
Yes.
But C is not framed in terms, as I understand it, that the claimant has got to pin his colours to the mast of a single liable defendant. The claimant might have a number of liable defendants that he could get at under C.
Yes.
But your case is that he should only go to E after he's dealt with C.
Indeed, I do.
Well, now, when one looks at the rule as a whole, which provides that the court may only make an order for an interim payment where any of the following conditions are satisfied.
Yes.
Might it not be said that if the drafters of the rule had intended that you could only get to E if you'd been through C and failed, then they would have said so?
That might be said, but in my submission, the danger of dealing with E before dealing with C is the court may not properly address the reasons why it cannot be satisfied the claimant will obtain judgment against an individual defendant.
But that doesn't add anything to your argument. I mean, your argument really is if you look at E,
yes,
it is not satisfied.
It is.
Full stop. It doesn't matter whether it would have been satisfied under B, under C, or anything else.
I agree, but what I'm trying to do is to assist the court to understand why I say Judge Bird went wrong, because he started at E, and what I'm also trying to do is to encourage the court to say that judges dealing with an application of this sort are best advised to look at C first and make sure they deal with C before they move to E, because...
But he clearly had C in mind, because he referred to it on a number of occasions.
Well, he said I can go back to C if I'm not satisfied at E.
But he also made the observation, which I think you would agree with, which is that C is, paraphrasing, where you've got clarity, and E is where you haven't.
Yes, I agree.
So he's conscious of
that. I agree he's conscious of it, but it's my submission that the judge... or the judge's decision doesn't adequately deal with the reasons why he considered that the claimant was not entitled to judgment for an interim payment against D2 under C, which was my submission. At the hearing, Mr Melton was saying, I rely upon E, and if not, I rely upon C against D2. My submission was, you've got to deal with you are entirely right, the application is entirely justified against D2 under C, and indeed as long as you're satisfied of that, then we don't even get to E. This was the argument on whether we should start with E or C. I was saying start with C, because if you start with C and you apply it to D2 and then D4, he wins against D2, not against D4 for reasons I'm going to go into. And I invited him to deal with it in that way, because I was anxious that if you just start with E, the risk is you don't think about it properly. It's very easy to convince yourself, well, I'm satisfied I don't know who's liable. That in my submission is the risk of dealing with E. If you ask yourself the question, am I satisfied I don't know which defendant will be liable, you can answer that question by not thinking about it carefully enough.
But all of these things are dealt with on balance of probability.
Yes.
So you may decide that on the balance of probability, he's going to succeed against YKS. And therefore, on the face of it, you could make a finding against YKS under C.
Yes.
But you're not certain. What's the position if you're still of the view that you probably would succeed against YKS, but you may also succeed against Buttar, and you are sure, or confident on the balance of probabilities again, that the prerequisites for success against one or other of them are satisfied for E.
Well,
you say E doesn't apply in those circumstances?
No, if on the balance of probabilities the judge is satisfied that the claimant will obtain judgment against two defendants, one of two defendants, yeah, then E is engaged. And if he is also satisfied on the balance of probabilities that he doesn't know which one, even if he thinks it's likely it will be against D2, but for example, not against D4, then it's not satisfied because it's on the balance.
But what if he thinks it's probable? So, what if he thinks that it's probable that the claimant will succeed against YKS, but he thinks that they may also succeed against Buttar, but he also thinks it's probable that he's going to succeed against one or other, but doesn't know how it's going to pan out.
Oh, if he thinks he's going to succeed against both on balance, then he is not engaged because it's got to be but cannot determine which. So if the court thinks, well, he's going to obtain judgment against both, E is not engaged, C is engaged. C is engaged against both, and indeed that's much easier for the claimant because the insurance requirement doesn't even then come in.
But you're creating a lacuna, because what you're really saying is once he's satisfied on the balance of probabilities that he would succeed against YKS, I'm going to call them.
Yes.
He is not entitled to make a finding under E against your clients, Buttar.
Yes.
Even though he is satisfied that if the claim went to trial, the claimant would succeed in obtain judgment for a substantial and against at least one of the defendants.
Yes, I disagree. I'm creating a lacuna. In the scenario that my Lord has just outlined, there's no lacuna. The claimant gets an interim payment from the second defendant.
Under C.
Under C. There's no lacuna.
But what you're saying, I think it may be my Lord's point to you, is that E would then only arise if the level of satisfaction that the court felt in relation to each individual defendant did not exceed a balance of probabilities, or was less than a balance of probability.
Under E, the court, this is the slightly odd feature of E, under E, the court has to ask itself, am I satisfied? I do not know which defendant will be liable.
There is a gap in that case, because you're saying that as soon as the judge says, well, I think likelihood 60% they'll succeed against D2, likelihood 40% they'll succeed against D4. At that point, you say E is off the table.
Basically, against both.
It might succeed against both.
If the claimant, if the judge is satisfied on the balance of probabilities applying the HMRC test, that the claimant will obtain judgment against D2, if he decides in his own mind on the balance of probabilities, so say 60%, the claimant will obtain judgment against D2, then the interim payment application succeeds against D2 under C. So there's no need to move to E because the claimant's got his interim payment from D2 under C. It's so E comes in where the judge is in effect is not satisfied against whom the claimant will succeed. It might be D1 or it might be D2. He's satisfied on the balance of abilities it's going to be one of them, but he doesn't know which one of them it is. In other words, it's a situation where if the judge has applied C to both individual defendants, he doesn't come to a positive conclusion. If when he applies C, the answer is no, I can't be satisfied, then you're in, but the judge concludes, well, I can be satisfied, it's going to be one of them, then you're in E. But if the judge concludes at C, in the affirmative against either defendant, you're not in E.
And so what does a judge do in those circumstances where the claimant says, I think I've got a strong case against my employer, but my employer is saying it's an unforeseeable event, it's all down to D4, and D4 is saying, I wasn't there, or I didn't see him, and I had nothing to do with it.
Well, that concerns the merits of it, then, Judge, and I'm going to come on to that.
But you've got to look at that because.
I'm going to look. I'm going to address it now. We're just dealing at the moment with the mechanics of how it works.
But if you look at the words
in abstract,
if you look at the words, the only question of principle seems to me is whether the words "but the court cannot determine which"
yes,
cover only a case where the court is not satisfied on the balance of probabilities as against either that the claimant will succeed.
Yes, I agree.
Or whether it is also apt to cover a situation where there is certainty that the claimant will recover against one of,
yes,
but the way that it's going to pan out is not clear.
In that second scenario, E does not apply in my submission.
That's your submission.
That's my submission because in that situation, the court is not finding I am satisfied that I do not know which of the defendants will be held liable.
Right, so E is, to put it colloquially, may or not be helpful, is in your submission just a whodunit clause.
It's a catch-all in many ways.
No, it's a whodunit clause. In other words,
yes.
I'm satisfied he's going to get money, but I can't tell against who.
Yes.
Is it also...
It is a whodunit clause.
It's a...
If you look at the case of Berry and Ashdead, which my learned friend kindly looked, it's worth having a look at that on the facts. I'll come to it later on, obviously, because it raises a point that was raised anyway in relation to the insurance. But if you look at that case, that was a case where you had an employer, the subjects of the application were an employer and another contractor, and the issue between the two defendants was who was the employer. There was a real dispute in that case as to who was the employer. One defendant was saying it's them, the other was saying no, it's you. So in that situation, naturally, the judge would be asking himself, well, this is a classic whodunit case. There's a breach of duty. It's a breach of duty but by the employer, but I simply don't know at the moment who is going to be found to be the employer. Can I just say...
Just before leaving this point, your submission is that as soon as a judge identifies a probability that a substantial amount of recovery will be made from one of the defendants,
yes,
that's the end of E.
That's the end of it. And can I just develop? Yes, I do say that, and let me just develop that briefly. I say that if the judge, if for the sake of argument, the judge decides, well, he's going to succeed against, say, D2, that's for certain, or highly likely, applying the HMRC test, but he might also succeed against D4, but I don't know. That does not fall within E. In other words, where it's going to succeed against one, and it might also succeed against another, that's not E. Also, issues of apportionment are irrelevant. If it's a situation where, for example, the judge thinks, well, I'm satisfied he's going to succeed against both, but I think actually one of them might be a lot more liable than the other one. One might be bearing 75%, 20, it might be 75, 25, or even 90, 10. That's irrelevant because, of course, the claimant can enforce the judgment for the full amount against either defendant if he establishes any liability. So that doesn't come into it in my submission. Issues of apportionment only ever concern defendants. They're nothing to do with the claimant. So in my submission, it's a mistake to think, well, if the judge thinks, well, it might be 91 and 10 another, that falls within E. It doesn't. claimant is going to succeed and can enforce the full amount against either one of them. There's no lacuna, that's in my submission, because the remedy is C. And if you go, and that's why I say, if you go through C first, and you ask in the case of each individual defendant, is C satisfied, that's a much better way of doing it, a much easier way of doing it, than going straight to E.
Does that mean that any claimant with two defendants in their sights who issues an application for an interim payment should always frame the application as being in C or E in the alternative?
Well, I'm very reluctant to
But that's the consequence.
Well, in an appropriate case, my lord, where there's real doubt about, in this case, for example, if there was real doubt about the identity of the claimant's employer, if it was being suggested, which it was not by anyone, that the fourth defendant was the claimant's employer, fine, no problem. But that was not the situation here.
What do you mean, fine, no problem?
Well, then it might be a clear case of falling within E. If there is if there was a real dispute between defendants as to the identity of the employer, as in Berry and Ashdead, then it might be a very
this
very
case is
quick
absolutely typical of personal injury litigation and litigation in other spheres as well.
Yes.
In that you've got two defendants. It's easy to see he's got a case against both. Sitting here, it's easy to see
Yes.
he's got a case against both, which may or may not succeed. And I'm speaking for myself, I can see why you would say the case against D2, YKS, is stronger than the case against
Yes.
your client for any number of reasons. But when he comes, just imagine that Mr. Melton had framed, or Mr. Lemmy had framed the application to be under E.
Yes, but it was then. Yeah.
Yeah. So only YKS turns up because you're not joined, or he says against both of you.
Oh, under C, mean you claim under C.
Under C.
Yes.
He may ask for an interim payment against each of you.
Yes.
Under C. You both turn up and go hammers and tongs about why neither of you is responsible. And what's the judge meant to do then?
Well, the judge, anybody making an application of this sort is going to make the application under C and or in the alternative, aren't they? In that
Well, that's
situation.
that was my starting point. The consequence of your submission is that anybody in this or a similar situation should always, any claimant should always apply under C or E in the alternative.
Yes, that would be a sensible thing to do. And regardless of how the application is framed, if the judge is looking at an application under E, regardless of how, assuming it's only been framed in that way, he should, in dealing with this question, look at C, because if he doesn't look at C as against any individual defendant, he may make a mistake, which is what I submit happened here, for reasons I will now go on to explain.
What would your position have been if this judge, who took considerable care of this, had said, well, I'm a bit worried about this, and as I've foreshadowed in paragraph 11, I'm now going to look at it under C, and I'm satisfied on the material I've got, because your client, your managing director, or whoever it was there on the morning and would have seen what's going on, he's probably going to succeed against D4 as well.
Oh, well, if he'd come to that conclusion, then I would have...
You'd be here on different
I'd be
terms.
on different grounds. I'd be here on the basis that C wasn't satisfied against me, but it was satisfied against D2, which is what I'm saying. It was satisfied against D2, but it was not satisfied against D4. If we look at where the judge dealt with this issue, I think it's paragraph 4, so paragraph it is paragraph 14 of the judgment on page 92. Reading from 4 lines down, he said this: "On the evidence as it is before me, I cannot be satisfied against which defendant judgment would be entered. At this stage, on the material before me, I can only take the relatively broad brush approach I have already outlined. Precisely where liability lies in my judgment and nuanced decision, which will depend upon the evidence and submissions at trial. As things stand, the material doesn't allow a firm conclusion one way or the other." He goes on to say, "I've mentioned the relationship between the claimant and the second defendant may give rise to a real possibility it will find itself with a substantial judgment against it. As I remind myself, the Court of Appeal have said a likelihood of that type is not enough." Now, I submit that passage does not address the evidence before the court or the parties' arguments in any detail. In particular, it does not explain how on the material before the court, a judge might conclude D4 will be liable, but D2 will not. The material before the court on this issue comprised the witness statement of the claimant, which the court will find at pages 26 to 29 of the supplementary bundle, the witness statement of Mr Buttar, the third defendant and managing director of the fourth defendant, which is at pages 63 to 75 of that bundle. The second defendant did not file any evidence, save a statement from Mr Chadder, a solicitor, who was acting for the first and second defendant at pages 31 to 36 of the supplementary bundle. Mr Chadder's statement did not contain any material which casts doubt on the claimant's employment status or the claimant's evidence about that issue. The second defendant's counsel at the hearing acknowledged there was little or nothing he could say about liability because no evidence had been put in about it. And we don't need to look at all three statements for the purpose of this aspect of the appeal. We can simply focus on the witness statement of the claimant. And that is because Mr Buttar's statement does not contain anything which undermines the claimant's case against D2. And no doubt if it does, then Mr Lemmy will highlight it. And that obviously is important because it's my submission that the claimant's application against D2 should have succeeded under C. If I could ask you to turn to page 27, please.
Before we leave the judgment, is it right to understand that effectively the thrust of what you've been telling us is directed towards ground 2.1?
Yes, I'm so sorry. Yes, it's 2A, that's right, 2A, or referred to as ground
2A,
2.
sorry.
Yes.
That basically your target here is 2A.
It is.
And the place where 2A is reflected in the judgment is paragraph 14.
It is.
Right.
It is, but also you need to look at the last sentence of 13. I'll come to that in a moment, but if I could just deal with it develop it in this way. If I could ask you to look at page 27 of the supplementary bundle, this is the claimant's statement that was served in advance of the application. All defendants saw this before the application was listed. It was listed and dealt with on the 10th of June. This witness statement is the 20th of May. Everybody had it a good 2 weeks before the application was dealt with. So this is the statement to which the defendants were expected to respond. If one looks at page 27 of the supplementary bundle and looks at paragraphs 8 and 9, the claimant gives evidence about the circumstances in which he was taken on by the second defendant. He explains in paragraph 8, he was put in touch with a man he knew as Gammy Brick, that's the first defendant, who was a builder and whose company was YKS Builders.
What's all this going to?
It's going to the issue.
We're aware, aren't we, that that you were not the employer of the claimant.
Look, if it's not in dispute on this appeal that the judge did or should have found that D2 was the employer, then we don't need then you don't need to look at paragraphs 8 and 9. All I was highlighting here was that on the material before the judge, there was clear evidence from the claimant that he was an employee of D2, and indeed that was the basis upon which this application was made. If you look at the skeleton argument of Mr Melton, filed in support of the application, which is at page 1 of the supplementary bundle, and in particular you look at paragraph 5 on page 2 of the supplementary bundle, you will see he says there, at paragraph 5, C's employer was D2.
Could you just pause a second?
Yes, of course.
Paragraphs 4 and 5 of the claim form. Paragraph 5, the second defendant exercised its control through the first defendant, and the first and second defendants owed a duty of care to the claimants under the regulations. And that's admitted by D2.
Well, the D2 admitted it exercised control of the claimant. Yes, it did not admit it was the employer, but put forward no material in support of that position. Either
The judge said it made no difference.
it should make no difference.
At the moment, I'm I'm sure you. I'm sure it's me, but at the moment I'm not understanding why you're labouring this point.
I'm so sorry.
Because the fact that there is an employer's duty
Yes.
towards this claimant is something that the judge assumed and doesn't appear to be controversial on this appeal.
Then that's fine, my lord. I mean, I just.
But I'm not understanding if it's a straight road, and it always has been a straight road. Why are we travelling it?
So be it, my lord. I didn't know what was going to be said about it, but...
Well, you'll have a chance to reply, but at the moment
yes,
your case is that they're very, very liable.
Yes, my case is that, well, the judge said, if you look at the last sentence of paragraph 13 of his judgment on page 92, he says, he says, in relation to the second defendant, I would find it was responsible for the claimant.
Yes.
So
you're not pushing back against the judge on this point at all?
So be it. Well, as long as it's clearly understood and accepted that the judge found and or ought to have found...
No, the issue that the judge was concerned about was whether you, as a principal contractor on a not very large building site, were able to escape responsibility for having something that on the face of it seemed like an extraordinarily dangerous arrangement.
Well, if that was the case, then we're not under... if he was satisfied about that, then that we were responsible, then obviously he would have found against us under C. We wouldn't even have got...
Right, so you get away because the judge could have found against you under a different part of the sub-rule.
But the judge was not satisfied. Certainly, the application was never suggested at the hearing that if he...
Well, if the alternative to E is that the judge should have found under C and not that the judge should have let you out altogether, and then this doesn't do you any good.
No, but the application, Mr Melton didn't even suggest on the application that if he couldn't get home against us under E, he could get home against us under C.
Yes, but the judge suggested it. I mean, the judge suggested that he could go back to C.
Well, yes, but that was in the context of Mr Melton's submission that if E didn't work, he would fall back on C against D2. But he wasn't suggesting that he would get home against D4 and C. Because there's an issue of fact about whether or not Mr Buttar had any involvement in this aspect of things at all. The claimant's evidence is he did. He was the one who told him what to do, as well as the first defendant. Mr Buttar disputes that.
There were two aspects, weren't there? One, whether Mr Buttar was there and supervised.
Yes.
Two, whether, so far as D4 was concerned, the placing of the joists were defective, but not evidently so because they'd been placed by an independent contractor, and therefore your client says you don't have any responsibility.
Yes.
So those, and neither of those could be determined on an interim.
Absolutely. Look, let's suppose the claimant's right. Let's suppose the judge was satisfied by the claimant's evidence, as your lordship suggested, and he thinks Mr Buttar was there and he did give the instruction, he was supervising. Okay, we're liable. But we're not in E, if that's the case. If he was satisfied of that, then he can't make the finding under E. Because if we've done that, if Mr Buttar is there and he's giving instructions and supervising, then not only are we liable, but D2 is liable because the duties are non-delegable. That's the point. The whole point of banging on about D2 being the employer is even if Mr Buttar, with no involvement from D2 at all, on the morning said to the claimant, right, can you just go and help out there, pass those bricks up, which was clearly an unsafe system of work, D2 is still liable because the authorities are perfectly clear in those circumstances the employer is in breach of his non-delegable duty to provide a safe system of work. That is the point, or one of the main points of ground 2. There's no way that we could be liable without D2 also being liable, because even if we had done wrong, even if we had done what the claimant says we had done, D2 could not escape liability.
So, if the position is that the court reaches the conclusion that the claimant is going to recover against either one or both defendants, just assume only two for the moment.
Yes.
You can't go under E.
Well, if the court concludes that it doesn't know against whom, whether it's...
And if the answer is either judgment against A or judgment against A and B,
yes, you're not
but I can't tell which.
if the court concludes it's either judgment against A or judgment against A and B,
But I can't tell which.
but I can't tell which of those two.
Yes.
You're not in E. What you're in is you're in C against A.
That's, as it seems to me at the moment, that's the nub of this appeal.
Yes.
That's the nub of this appeal, isn't it?
But the court cannot determine which. The question is whether that is apt to describe a situation in which the court cannot determine whether it's one or both.
Thank you for clarifying that. I'm grateful for that. My submission on that point is the court can determine which defendant is like. It can determine that one defendant.
No, that treats which as if it's got to be one person or another person, whereas which is apt, as it seems to me at the moment, to encompass a situation where the court cannot know what the outcome is going to be as between the two.
Let me just develop the submission. The court can determine which. It can determine that D2, on the fact that in this case D2 is liable. What it can't determine is whether D4 is also liable as, let me just finish, as also liable as well as D2, and it can't determine the apportionment. But E has got nothing to do with issues of apportionment because the claimant.
I'm not talking about apportionment here. I'm talking about liability.
Yes.
For a substantial judgment.
Yes. Yes. I understand.
I take your point about apportionment.
Yes.
But that's really we get down to the word which, and what that means.
Yes.
And certainly, because of the clarity with which you dealt with it, I understand your point about it.
Thank you for that, my lord. And I think we've probably exhausted that point. Then, if we are, if that's the interpretation the court puts on it, and it's content.
Well, obviously, I'm only speaking for myself.
Of course, I understand that. I must say that the way that the judge dealt with it in 11 was not really along. He didn't deal with it along the lines that my lord has outlined. He didn't say, "Well, I'm satisfied against D2." And the issue is, am I also satisfied against D4? I don't know, and therefore it's E. He dealt with it in a different way. He dealt with it on the basis that he didn't know if the claimant was going to succeed against D2 at all.
Yes.
And that, I submit, he was wrong about that. He was clearly going to, claimant's clearly going to succeed against D2 for the reasons I've outlined. I simply say on this, if you come to that conclusion, then it doesn't matter whether you're also going to succeed against D4, because what this provision is really designed for is many of the road traffic cases where there's an innocent passenger or pedestrian injured and obviously not their fault, and the court has to, as it frequently does in those cases, doesn't want to leave the claimant without a remedy.
Is it your submission that D2 is liable under its non-delegable duty if the joists were placed by an independent contractor of D4 and had a latent defect which no one could sensibly have found, and it failed in those circumstances, which is...
No, it's not. In fact, if it's the case that what happened here was that the joists that were installed were either defective joists because of some kind of latent internal defect. Then I would, my submission at the hearing was, well, in those circumstances, neither defendant is liable. Likewise, if they were installed in such a way that they were hung defectively, so they weren't secure, again in a way which wasn't detectable upon a reasonable examination, again, neither defendant would be liable. That was one of the submissions I made in my skeleton before the judge.
Well, that's what I thought. So the non-delegable duty goes so far and no further. You accept that, at least in theory,
yes,
it is possible for the, I know you say it won't happen, but
yes,
for D2 to escape on the basis that it's an accepted system to stack bricks and blocks on joists, which sounds a bit surprising to me, but this happened not because the wall was inadequately built by D2,
yes,
but because the joists failed,
yes,
in circumstances which are not attributable to
yes.
negligence.
I mean, if I'm being absolutely fair about this, and I must be,
It's a good idea.
Then I'd have to acknowledge that Mr Buttar's statement did say, look, after this accident, the same joists were put back, and there was nothing wrong with them, and they'd been, and the framework had been checked by building inspectors and passed. So there wasn't much material, put it that way, before the judge.
But again, being absolutely fair, I think you would say that's the only route by which the second defendants escape.
Well, I would say both of us, not just D2.
You say you would both escape, yeah. But you would say that's the only route by which D2 escapes.
I submitted to the judge, you'll have seen my original skeleton argument, that if that's what happened, if the timber joists collapsed for reasons which were to do with either the supplier of the joists or the installer of them, neither of which are parties to the proceedings, then the application does not succeed against either of them. The difficulty I had with making a submission on that issue was that there was not really any material to support it. I hadn't pleaded that, and although it was in D2's defence, there was no material before the judge to suggest that that was anything other than a theoretical as opposed to a realistic possibility.
Statement of truth.
Well, there's a statement of truth in defence.
Could I just tax you again on E1?
Yes.
In trying to unpick this, the court has to be satisfied that the claimant would obtain judgment for a substantial amount against at least one of the defendants.
Yes.
I'm focusing at the moment on at least one of the defendants, but the court cannot determine which.
Yes.
That seems to me to point in favour of the construction that I put to you a moment ago, which is that it would be covered by the I'm not sure about whether it's A or A and B, rather than the case you're putting, which is I'm not sure whether it's A or whether it's B. Because had the rule wanted to say that it was only applicable where it was, as I've described it, a whodunit, an A or B, then the words at least one would be otiose, because it could simply have said the claimant would obtain judgment for a substantial amount against one of the defendants, but the court cannot determine which.
Well, I would counter that by saying then why, at 2, do all defendants have to be insured, or a public body, or the MIB? I mean, if my lord is right, and it covers a situation where it's definitely one and it might be another, then why does the condition in 2 apply to all and not merely the ones against whom it might be?
Because if you end up in your position with an interim payment ordered against you and against D2, who for the purposes of argument is going to be solely liable eventually, your protection is that they're either a public body, or we needn't even worry about the MIB in the present case, or they're insured. And in this case, it's they're insured, and that's your protection.
Well, but why do we have to be insured then? What's the protection for?
The protection is to ensure that when under 25(8) the court adjusts the interim payment, it's not a waste of time, because D2 is insured. We hope will still be insured. But that's the measure of protection that the rule's given you.
Well, I'll come on to the protection in a moment, but I would submit the words cannot determine which are not apt to cover a situation where the court can determine that actually one of them. What you're really saying in those circumstances, it can determine the issue in relation to one of the defendants. It just simply can't determine the issue in relation to one of the other defendants.
Coming back to a suggestion I made rather badly earlier, and I'll try and make it a little bit better. That's a reasonable. My lord's suggested interpretation of E is reasonable when throughout you're only dealing with balance of probabilities, and you get a wider spread of cover for the claimant, and you get the protection which you're going to deal with in a moment.
Yes.
That as between the defendants, they're both they're both, at least those 2 defendants are insured. So that's what's wrong with that.
Well, you do get a wider spectrum of cover, but it's not in accordance with the rules.
So we come back to the word which.
We come back to the word which.
Yeah. Okay. Thank you.
If my lords and my lady are content with exhausted rounds 1 and 2, or at least, I don't know whether we reach the end or at the beginning again, then I will move on to grounds 3 and 4.
Thank you.
Or I should say, well, it's grounds 2B and 3 is set out in the grounds of appeal. They're on page 13 of the appeal bundle. It's all grounds 3 and 4 in the skeleton, which are at pages 22 to 24. And I shall address each of these in turn. The second limb of E provides that under subparagraph A, the court must be satisfied all defendants are insured in respect of the claim. The court has asked, does that refer to all defendants to the claim or all defendants against whom the application is made? The answer to that question is provided by the decision of this court in Bury and Ashstead Plantire.
It's obiter, but neither of you are asking us to depart from it.
No. I understand Mr Lemmy has forwarded a copy of that case. The key point, it seemed to me from reading that case, is that the court will not get to the second limb of paragraph E unless it's satisfied on the first limb that the claimant will obtain judgment against one or more of the defendants to the application. So as long as the court's satisfied on the first limb, then the risk of neither of the defendants to the application being liable, but only another defendant who is not the subject of the application, is probably minimal. So I don't propose to address that further. It's not a point I'm taking in the context of this appeal. Returning then to the grounds of appeal, and in particular the judgment, the judge identified correctly at paragraph 16 of his judgment on page 93 that the second limb of paragraph E is a condition precedent which must be satisfied. And in particular must be satisfied before one moves to the issue of whether or not the court should exercise its discretion to make an order. He went on to say the words in respect of the claim simply make clear there has to be a policy which covers the risk. In other words, the claim being brought is one that falls within the scope of the policy. He noted at paragraph 17 on the same page that the insurers of D2 and D4 had reserved their rights, and by that I'm sure he meant reserved their rights in relation to their liability to indemnify the second and fourth defendants. That wasn't said expressly, but that's clearly what he meant. At paragraph 18 on page 94 he said this: I must consider the question then as matters stand before me today. If I ask myself, are the defendants insured in respect of the claim? The only and obvious answer is, yes, they are. The fact that the insurers have reserved their position is not a matter that affects that position. It is a matter simply between the insured and the insurer. It may be, in due course, that one or other will repudiate, but until repudiation takes place, as of today, the defendants are insured. It would result in unfairness if a party was to be treated as uninsured simply because its insurers were reserving their position.
You left out the words in brackets.
Yes, I did.
But they show that the judge was on the button, because there is a question which immediately arises in the mind of anybody who's used to dealing with insurance,
yes,
about what the effect of a reservation of rights is. And
yes.
It does not have the effect of bringing the policy to an end.
No,
and even a repudiation doesn't necessarily.
No, I agree. I agree with that. What I was going to focus on initially, I will deal with that. What I was going to focus on initially was, I didn't mean to deliberately omit those words. Incidentally, I wanted to focus on the last sentence of what I quoted, and for reasons I'm about to explain. And the judge does not explain in that sentence what he means, but in context I assume it's a reference to unfairness to the claimant. And he doesn't seem to have considered, in my submission, that if an order is made against multiple defendants and one or more of their insurers declines to make an interim payment, because they've reserved their rights under the policy, there's the potential for substantial unfairness to the defendant whose insurers won't meet the order, and to those defendants who do meet the order but in the end are found not liable. And that unfairness arises because a defendant who is the subject of an order under subparagraph E is necessarily a defendant against whom the claimant may not succeed.
So what information was put forward by the defendants, or most particularly by your defendant, for the judge to consider in relation to this issue about, firstly, are they insured, and the other issue, which would be the discretion point? What did you do to assist the
I
court
can
on
do
that?
that now, my lord. I was going to make a few other points and then direct it.
Well, could you just say that I can
Yes, of course,
understand?
my lord. Absolutely. Well, the material that was put before the court by the second defendant comprised the statement of Mr Chadder, which I've highlighted was at page 31 of the supplementary bundle, and that exhibited a letter from the solicitors acting for the second defendant's insurers, Faraday, which you will find at pages 40 to 43 of the bundle.
And it's really 42, isn't it?
And it's really 42. And the evidence put forward by the fourth defendant was paragraph 6 of the witness statement of Mr Buttar, which starts on page 63 and continues on page 64.
So there is, in fact, no information about the basis of the reservation of rights by your insurers. But you're instructed by text.
Yes, that is correct. It simply says there's a reservation of rights whilst our insurers investigate and consider whether to grant an indemnity.
But you're instructed by Plexus, who, as is well known, are insurance solicitors, and presumably you're instructed by them under the reservation of rights.
Yes, that's right, but we're not instructed on behalf of the insurers of D4 in relation to the indemnity issue.
Okay.
Sorry, what was the page reference to your?
63 to 64,
Yeah.
paragraph 6 of the witness statement of Mr Buttar, my lord.
Yes, thank you, I've got it.
Thank you. Returning to what I was saying, I will address this in detail in a moment.
So just picking up my my question then. Beyond what appears in those few lines, you put forward no information about your insurance position.
No detailed information.
No. I mean, beyond saying
Indemnity has not been
it's
granted.
up in the air, you put forward no information.
Well, I think the words say indemnity has not been granted, or indemnity has not been confirmed.
Yeah.
In policy, indemnity has not been granted.
Right. In terms of when we come to discretion, you didn't, for example, put forward any information saying that we, as a principal contractor on a site of this sort, will be in grave embarrassment having to make an interim payment of this sort.
We did not, but my lord, I'm going to come to that issue in a moment. As to
No,
what...
but did you put forward any information about the impact of an interim payment of this sort of size
I don't think we did.
upon you?
Can I just double check that, my lord?
If I can put it this way, you nailed your colours to the fact that you said you weren't insured within the meaning of
Yes.
E2.
Well, this is it. I don't think we did. It's a long witness. Forgive me. I'm just looking to see whether or not there was anything else said about that. No, we did not, my lord.
Thank you.
And returning to the, and I will come on to examine this, and I will also deal with the issue of what it's reasonable to expect a defendant to an application like this to put forward. I'm going to come on to that in a moment. But at the moment, the point I simply want to make, I was making the point that the judge has focused on the unfairness to the claimant. From this, in his judgment, the sentence I highlighted, I submit there's potentially unfairness to the defendant. And that unfairness arises because the defendant who is the subject of an order under E is necessarily a defendant against whom the claimant may not succeed. In other words,
Yes, all right. It's a theoretical possibility of unfairness, but you didn't advance any substantial information to say that although this man was crushed on our building site, it's going to be terribly unfair for us to be asked to support his rehabilitation in the interim.
It's unfair, my lord, because we might not be liable if the claimant. That's the reason it's unfair. Not for any other reason. It's unfair because we may have no liability to the claimant for his injuries. And if we have, at trial, no liability to the claimant for his injuries, it is unfair and unjust to require us to make any payment to him whatsoever.
That, to my way of thinking, is the consideration which raises a question about what Lord Justice Longmore said in Berry. Because one can see how greater protection would be granted if the word all the defendants meant all possible defendants who, by definition, the claim is brought against them, could succeed. I know we're not going there today, but
yes,
but there is what I'm saying, I think, provides you with some support for what you've just said, which is if you're under C and the court's satisfied that your client is going to be liable,
yes,
then the unfairness about which you're protesting goes.
yes,
If your criticism is, it's a bit like mesothelioma.
yes.
You don't know, you can't prove causation, you can't prove this,
Yeah.
but
It's
you
material
still
risk,
have,
isn't it?
Yeah, bad luck.
This isn't. I don't think anyone would suggest that those causation rules should be adjusted
No,
in a case like this.
no,
But
tempting.
I understand what you. Look, this is a case where absolutely. I mean, I acknowledged in my skeleton argument to the judge, there is no, in many ways, there's no just solution to this application, apart from in circumstances where the D2's insurers will not pay and have not paid, including not paid the order. I mean, there was a clear case against them for an interim payment. It should have succeeded under C, and an order was made against them, which they've not appealed and not paid. The reason I focused on that last sentence, referenced by the judge to unfairness, was because in my submission, the answer to what the condition precedent in E means is not to be found by looking at the potential consequences for a claimant. The key to understanding E is to ask why the condition of insurance exists at all. It does not exist in relation to A, B or C of the rule. The reason it exists in relation to E only is not for the claimant's benefit. In other words, it's not to guarantee an order for an interim payment will be paid to him. It is to protect the position of the defendants who may well be exonerated at trial. It is for their protection, not the claimant. It's designed to ensure if a case goes to trial and the claim succeeds against one or more of the defendants, but at least one of them is exonerated, that defendant is reimbursed. It is to minimise the risk a defendant might be ordered to pay out at the interlocutory stage, exonerated at trial, but then not be able to recover the monies the court has found it was not liable to pay. In many circumstances, the claimant will not be able to repay because it will have been spent on things like rehabilitation, and the defendants who are liable to the claimant may not be able to pay because of the lack of their own funds or because their insurers may repudiate. The judge commented in the last sentence of paragraph 18, you will see on page 94, he said this, reading from 4 lines up from the bottom: secondly, if the insurers come to the conclusion they might repudiate and they do so before the date on which the order requires payment, it seems to me the insurer would not be responsible for payment. In my submission, that reflects a misunderstanding as to why all defendants to an application have to be insured. They have to be insured for the protection of the defendants themselves.
But this is not an answer that we're not going to find the answer in policy. It's what do the words of the rule mean?
Yeah, I understand that. Well, the judge said this. He said, I think in paragraph 16, that the words insured in respect of the claim do not he said the words in respect insured in respect of the claim mean, is there a policy that will cover the risk, effectively? That's the question that he posed for himself. Is there a policy that covers the risk? That's in 16 and 18. My submission is, the correct question in law is, are the defendants indemnified? After all, if you're not indemnified, you're not insured. That's why it's not simply a question of, is there a policy that covers the risk? The question is, is the defendant indemnified?
This is impossible. At the moment, we know that insurers have issued policies, EL, we understand, to
yes.
YKS, and PL to you.
Yes.
This court is going to say, I strongly suspect, speaking entirely for myself, that such a policy, provided it was in force at the time, should cover any liability. Any normal policy would cover the liability that might be incurred as a result of this accident. Yes. Right. All we know, and all the court below knew, was that there had been a reservation of rights with no information about why rights had been reserved, so no possibility of making an assessment, and not even having the policy, which would have been in your power to put before the court, not even having the policy wording to be able to start to assess whether there's any possible grounds. Now, I'm not for one moment suggesting that the reasons that this applies to either your insurers or to D2's insurers, but if one were to say that the mere fact of reservation, which has no contractual effect at all, apart from allowing insurers to conduct their inquiries without prejudicing their position, means that the client is not insured, the scope for a less than scrupulous insurer simply to reserve rights
I agree.
Absolutely in headlights.
I'm going to come on to that. I recognise that that's a potential problem, and I'm going to deal with that in a moment. I understand the concern, and I will deal with it, but I don't agree with your lordship that there was little or no material before the court. And I accept that well, I'll look at what the judge said in a moment, but if you just look at the material that was before the court in relation to D2, it's set out in detail on page 42 of the supplementary bundle, under the heading Underwriter's Current Position and under the heading Conclusion. And at page 42, the letter could hardly have been clearer. If an interim payment order is made against Mr Sangira and or YKS Builders Limited at the hearing, underwriters will not provide an indemnity in respect of that order.
And that may be a clear breach of contract on that.
It may be.
We can't judge.
No, but well, if we look at the earlier paragraphs, they set out the underwriter's position for the benefit of the parties and the court.
What is the position of the second defendant got to do with it?
Because it's all to do, unless all defendants to the application are insured, then the risk I've identified is if the claim succeeds against D2, but it doesn't succeed against D4, and D4's made an interim payment of £150,000, and we then say, right, we want repayment of the 150 that we paid several months ago, D2 says, well, sorry, but we're not indemnifying D2,
yes,
we won't get the money back.
I've caught up, thank you.
Sorry, forgive me. So looking at the letter on page 42, it says in terms in the middle paragraph, underwriters' investigations to date have been hampered by a failure by Mr Sharma, the director of YKS, and Mr Sangira to provide assistance. The loss adjuster has made request of documents and information these have not been complied with in full. The loss adjuster has requested a further meeting today, but neither Mr Sharma nor Mr Sangira have made themselves available. Similar requests by this firm have been ignored. Underwriters are concerned they conclude their investigations and make a decision on indemnity as soon as possible. The insurance issues are complex and detailed, and there is regrettably no realistic prospect of this happening, either by the date of the application or in the near future. So that's what they said, and you've seen what the third defendant has said. And I submit that based upon the material before him, the only conclusion open to the judge under under the second limb of E, was that it was not satisfied, and it was not satisfied, and he didn't get the right answer because he didn't ask himself the right question. He should have said, are they indemnified? Not simply, is there a policy that covers the risk? If he'd said, are they indemnified? That would have been it. Now, if your lordship's not with me on that, then obviously we come on to the issue of discretion. And here, in my submission, the judge failed to weigh in the balance the risk, which was plainly more than fanciful, that D2's insurers will ultimately refuse to indemnify D2 and reimburse D4 if exonerated. And I would add to that, albeit I appreciate the comments that have been made about the paucity of D3's evidence on the issue, he also failed to weigh in the balance the risk D4's insurers will fail to meet the terms of the order, leaving D4 to pay it themselves. He dealt with the exercise of discretion at paragraphs 19 and 20 on pages 94 and 95. In paragraph 19, my lords and my lady will see, he refers to O'Driscoll and Slay, a decision of the Court of Appeal on the 20th of November 1984, and in particular the decision of the then was Lord Justice Griffith, which I think can be found at page 17 of the supplementary bundle. It's the top of the first sentence at the top of 18, where his lordship said, I read the purpose of the predecessor of the rule as making provision for interim payments only where it's likely that the order will be met. And the judge adopted that test. We go back to the judgment in paragraph 19 on page 94. He asked himself, on what basis can I be satisfied it is reasonably likely the insurer will not pay out? That's reading 3 lines up from the bottom on 94. And he said that he comments that the evidence and argument suggesting the insurers have a contractual right not to pay out or an entitlement to repudiate is, quote, very thin. He says it's a mere assertion in a letter written by solicitors who are not on record for any party in the case. And then, of course, he went on to say, when dealing with the exercise of discretion at paragraph 20, he says, this is on page 95, if at trial a defendant is found not to be responsible or to a far lesser degree, the court will readily order repayment. And again, in my submission, he seems to have proceeded there on the same basis, namely that the evidence that either insurer, and in particular D2's insurer, will not pay out in the end is very thin. Certainly he doesn't acknowledge it's a real possibility. So he seems to be unimpressed, distinctly unimpressed by the evidence that's being put forward.
Well, he deals with it.
He does deal with it, but
he squares up to it.
I understand
reaches a conclusion, and presumably you would accept that on an issue of discretion of this kind, we could only overturn his conclusion if we were satisfied that it was effectively perverse.
Well, I've got something to say about it, but with respect to the judge, he appears to have elided the issue of whether the insurers are likely to pay out with the issue of whether a refusal to do so would be justified. The implication from the judge's comments in paragraph 19 is that either the second defendant or the fourth defendant should have put before the court evidence that would tend to show that either one or both insurers would have justifiable reasons for refusing to indemnify. In my submission, that is not realistic. The obligation the judge impliedly put on the defendants to adduce evidence before him in support of potential arguments by their insurers to refuse to indemnify themselves was not one that they had any interest in fulfilling.
May we take it that your lay client's position, D3 and D4, is that D4 is entitled to be indemnified?
Subject to a full reservation of rights.
No. Is it your client's position that they are, as a matter of fact, entitled to be indemnified? I know there's a reservation.
Oh yes, absolutely. D4's position, of course, it's a matter of fact that they are entitled to a full indemnity. That is not the at the moment. I'm instructed under a full reservation of rights.
Well, we know that, but I know they're not here. But can we safely assume that the position of D2 was the same before the judge? that they were saying they were not accepting that the reservation.
Oh, absolutely. I'm sure that's the case. I mean, I think it is.
Yeah, well, forgive me for asking an obvious question.
No, I understand. Well, I doubt anyone in D2's position facing a claim of this magnitude would say, yeah, we accept we're not insured.
No, and also, they're in the stronger position. It's an EL policy.
Yeah.
With all that implies.
Yes.
Well, in that case, surely it's if you say you're indemnified, they say they're indemnified, then presumably one or other of you's got to put forward some decent information to the judge to establish that you're wrong.
Well, no, that is absolutely not the case. Self-evidently, a defendant in this situation cannot be expected to produce evidence to the court which shows its insurers might well be justified in repudiating their policy.
Well, then how could the judge, if you say I'm indemnified and you're under no obligation to show the contrary, what's wrong with the judge finding that you're insured?
Well, because the judge might then make the order and the insurers might turn around and say, well, that might be your view, but it's not ours, and we're not going to pay the order.
Or we come straight back to the danger which you said you were going to deal with.
Well, in my opinion, it's just not in the defendant's interests to start putting before the court on an interim payment application evidence as to why their insurers might be fully justified in being suspicious.
Well, of course, I mean, that speaks for itself, but so what?
Well, so what? Plenty in my submission. The judge has decided, when exercising his discretion, that the evidence is very thin. Well, the reason it is very thin in my submission, well, I don't accept it's very thin, but it's not realistic in my submission to expect, for example, D2 to give chapter and verses to the weaknesses in their own case on the indemnity issue.
All right.
And likewise D4. I mean, if they do that, they run the risk that the insurers will then say, well, thanks very much, you're definitely not indemnified now.
Yes. Well, the judge said, did he not, that he was approaching the discretion point. Paragraph 19, lines 5, 6. Balance the reasons which favour making of an order and the reasons which go against it. Powerful reasons for making an order, that seems uncontentious. And then he goes on to consider the material that he has against it and reaches a conclusion.
I accept that, but well, this is not a conclusion based upon hearing oral evidence and deciding whose evidence is to be preferred. This is a conclusion on written materials. So it's either...
No, I mean a conclusion for the purpose of the application.
Well, I understand that, but I submit that his comment that the letter from D's insurers was very thin was wrong. It identified matters of real concern, specifically a lack of cooperation in the provision of documentation, information, and a willingness to be interviewed. And that was borne out by the fact there was no statement from the first defendant.
For example, we don't even know whether there's a term of the policy which makes it a condition precedent to indemnity that the insured cooperates. And that is not a term that is necessarily to be implied.
No, but that wasn't the only issue that was identified.
No, but it only goes to my lord's. It goes to my lord's point that or the judge's point that the information provided is very thin.
Well, I submit that letter on page 42 is not. It sets out about as much detail as you might expect from the insurer's solicitors, who are still acting under a reservation of rights. It's understandable why they would be cagey in revealing the state of their investigations, what they've got so far, what that leads them to conclude, what they hope to get, because of course they're not simply potentially dealing with litigation from the claimant. They might be in litigation against the defendant. An insurer acting under a reservation of rights is not going to want to say to its client, well, this is what we suspect you've done so far. These are the terms we think you haven't complied with or haven't told us the truth about. And if we find out X, Y, Z, we're going to pull the indemnity. I mean, insurers acting under a reservation, conducting an investigation, are not going to do that because they're going to risk prejudicing their own rights. In my submission, an interim payment hearing is not an appropriate venue for discussion or an analysis of the merits or otherwise of insurers' potential refusal to indemnify. The defendant themselves won't want to start revealing to the court all of the reasons why the insurers might well be justified in pulling the indemnity. The insurers themselves, if they're acting under a reservation, might well have good reason not to want to have to reveal the state of play so far, or what they suspect.
Sorry to interrupt you, but I mean, all of these problems only arise if one kicks off from your submission that insured means indemnified, which is...
Well, I'm not sure that's right, actually. With respect, no, that's obviously the condition precedent. But when we come to discretion, even if condition precedent is satisfied, then when we come to discretion, then no, I don't accept that the submissions I'm making only apply, because we don't even get to the discretion if I'm right about the condition precedent. We get to the condition precedent, we don't even move on to these arguments.
All right, I understand.
So we only get here if the judge says, well, if the judge is right, that the issue is there simply a policy that covers the risk? If that's the issue, then fine, then there was, okay.
Yes, but
then on the discretion...
I follow what you say about it being relevant to ground 4 and discretion, but it all reflects back on whether insured really means insured or whether it means indemnified. Because if it means indemnified, then one gets into all these difficulties even at the prior stage.
Well, you do encounter those difficulties, but my main point on the discretion, if we're into discretion, my submission is that if we're in a situation where yes, there is a great need on the part of the claimant, understood and accepted, but there is also a very real risk that the defendant who makes the payment, in this case ourselves, is subsequently exonerated at trial and cannot get that money back. And that is not a small risk.
Your argument on ground 4 has got to be this, if you haven't succeeded hitherto,
Yes.
which is that you are insured, but on the basis of the material that was provided by D2 and yourselves, the judge was bound to find that it would not be right to order an interim payment. That's what you need to show.
Yes, I submit that's, as I say, I submit he elided 2 issues. What he focused on was there a justifiable reason? Because when he was exercising his discretion, he was looking at whether or not the insurers had good reason to refuse to indemnify. And that's where I submit he was wrong, because let's suppose, for the sake of argument, that both insurers have said, right, we're pulling indemnity. You're not indemnified, but they've done so for reasons which are not good ones, which we're not going to stand up. Where does that leave us? Well, I could come back to the point. An interim payment hearing is not a venue for a detailed analysis of whether the insurer's actions are right or wrong, or justifiable or not. If the insurer says we're pulling the indemnity, then that is an end of it. And if they say, well, there's a reservation of rights, as they did here, and as long as they're not acting in bad faith, and getting back to the point I said I'd deal with this. Clearly, if there was evidence of bad faith on the part of the insurers, the position might be different. I can accept that. But if there is no bad faith, and there's no suggestion here that there was, then the risk that I have identified is a very real one.
Yes.
And the judge's comment at paragraph 20, well, he said, look, at 20, under 25.8, if one of them is found not to be responsible, the court will readily exercise its power. Well, of course it will. It will exercise the power, but whether that to order repayment, but whether that will do the winning defendant any good is a completely different matter. That offers us no reassurance whatsoever if there is a real, as opposed to a fanciful risk, that D2 will not indemnify, and there clearly is at the moment, given the contents of their letter, which could not have been in starker terms.
Thank you.
So those are my submissions on grounds 3 and 4, unless there's anything else that I need to address.
You've been very helpful, Mr. McLaughlin. Thank you very much indeed.
Thank you very much, my Lord.
Yes, Mr. Lemmy.
My Lord, my ladies. The first ground is a complaint about the order or starting place when considering an order for an interim payment. In my submission, there's nothing in that point. The rule's clear, 25.71, the court may only make an order for interim payment where any of the following conditions are satisfied, and then we have A, B, C, D and E, and it's a nonsense to suggest that in a PI claim you should go through those starting at A and consider whether there's an admission or a judgment when there's no admission or judgment. It's a nonsense to suggest that in a PI case you should go through condition D, which is to deal with the possession of land, when what you're really concerned with is subparagraph E. So you go straight to it, and that was the starting point in this case. That was what the application was brought under, made clear by Mr Melton, and that, in my submission, is the end of the ground 1, the order or starting point. Can I deal then with ground 2? 2 parts to ground 2. We say, in respect of the first part, the judge was correct in his finding that he couldn't determine whether D2 or D4 or both will be liable or not. And that's a nuanced decision for the trial judge. And he gives his reasons for that. In my submission, on an interim basis, he's not to be criticised for that.
Mr. Levy,
there's
can
nothing
I
wrong
just
with that. Yes.
tell you what's worrying me about that particular submission? I strongly suspect that a significant number of judges, if presented with a claim under C against D2 only, would have taken what in other circumstances might be called a robust view and found that they could be sure, because it's a strong case. Yes. On any view. The question really is whether the judge was entitled not to follow that robust line, but to take a more cautious approach.
Well, let me deal head on with that. I mean, it may be that it's dealt with under the second point of ground 2, which is what you've been interested in, which is the interpretation of the word which, and I'll deal with that. But I say the judge is correct to say he can't determine against D2. It's not that clear cut. It might be that we probably would succeed against them, but that's not enough in my submission. Court's got to be satisfied that we will succeed, that we will obtain judgment against them. And Judge Bird, looking at this, in a broad brush way, decided that he couldn't be so satisfied. And it's a binary decision. And you'd have to be satisfied that his decision was effectively perverse in that respect before you could interfere with it. It's not sufficient that other judges might come to a different view or take a more robust view. And in my submission, he's entitled to take a cautious view, because wouldn't we have D2 stood here saying, well, the judge took a robust view, and on an interim payment application against one defendant under C, who doesn't even have to be insured, they should be cautious. And that's why the wording is not just likely to succeed, would succeed. And that's a relatively high hurdle. And that is, in my submission, the court saying judges should be cautious. So we say he's correct in relation to that for all of the reasons he gave. The interesting point is if he's wrong about that decision. So let me move directly to that. We say that the wording of subparagraph E does not preclude an order against any number of defendants who are insured if the court is satisfied that there will be judgment against one of those defendants, but can't determine the liability of all of them.
Are you happy with Mr McLaughlin's point about it's not about apportionment? It's about liability.
It's not about apportionment, and it's not about identity. And what Malone and Friends trying to do is to limit the scope of the ability of the court to make an interim payment order. So he says, well, it's appropriate for the whodunit cases, where you've got two defendants arguing about who the employer is. Well, which one is who it is?
Or you've
it's
got
the
a
whodunit
driver
case.
and you've got a passenger and two drivers who would be
two occupants seen getting out the front of the car. Which was driving? Obviously, it fits that case, but it's not limited to that case. And Malone and Friends' submission seeks to get you to limit it to that case. Not the RTA, where you might have 4 cars colliding in a row on a motorway, and the court might think, well, I'm satisfied the driver, the man who ran up the back last, wasn't paying attention, there'll be a judgment against him. I'm not sure whether the first car, the second car, or the third car's liable or not, but they're all insured, so I want to make an order against all of them. And I say that subparagraph E in my submission allows you to do that. So
if it was a road traffic accident, you wouldn't be dealing with is insured, you'd be dealing with insured or motor insurance bureau.
Yeah, probably is insured, because it's only where someone's not insured that the MIB stand in their place.
So the motorway pile-up case, you say, is interesting to consider
It's interesting
in the context of E.
Yeah, the alternate whodunit case was at A or B. That's interesting,
Yeah.
and that's what my learned friend prays in A, but it really limits the scope, whereas the motorway pile-up case is actually a real day example.
So is it A or A and C, or A, B and C, or A, B and D?
Yeah.
And the fact that it's going to be 1, 2, 3 or 4 of them does not mean,
or any combination of
or any combination does not prevent you from going under E.
Precisely.
Can you say, I suppose, it's a necessary or desirable protection in the circumstances of the present case? Imagine you had three defendants, but it can do with 2, and one insurer is reserving rights. The fact that you can get an interim payment against both provides the claimant with a degree of protection which is necessary.
Well, I respectfully submit that there's protection to the claimant, there's protection to the co-defendants from each other because they're insured, but also because they're insured, or a public authority, or an MIB, the hardship to them, if it goes wrong, is more limited than if we were dealing with a Category C case where they were uninsured. So it's important to, in my submission, appreciate that the rules make categories of cases where interim payment orders can be awarded by the court. One of those categories applies only to parties who are insured, or public authorities, or the MIB. And it's a different, I submit a lower threshold that has to be got over than under Category C. What Learned Friend says, no, it's as difficult. It isn't any easier at all. Well, we say that's not right. I too would seek to refer you to the Berry Authority that only came before this court as a result of your Lordship's inquiry a few days ago. But because on page 5 of the transcript, it's page 65 of the bundle, I've highlighted the relevant extract, which makes it clear that it's only the parties against whom the order is being sought that have to be insured. But you'll see at the bottom of the page above that, page 4 or 64 of the bundle, that the former RSC Order 29 Rule 11 set out. And it's interesting to observe that paragraph 1C of that says that if the action proceeded to trial, the plaintiff would obtain judgment for substantial damages against the respondent, or where there are 2 or more defendants, against any of them. So under the former rules, my learned friend's argument wouldn't succeed.
But the rules have changed.
But the rules have changed. Were they meant to have restricted it in the way he says, only to cases of mistaken identity? Or were they meant to apply to cases where you're going to get judgment against one of the defendants? You just can't determine which of the defendants you're going to get judgment against. You're going to get judgment against D2? Yes. D4? Don't know. D5? Maybe. You can't determine that. So I submit that the words, but the court cannot determine which, means the court cannot determine which defendants, plural, the judgment would be obtained against.
Defendants, plural, not which defendant, singular.
Precisely. Obviously. And read that way, well, my learned friend conceded in all submissions the judge couldn't determine whether the claim would succeed against D4. It may or may not, and therefore the rule's satisfied. So we say the interpretation is as simple as that. It allows the court, in cases where the parties are insured, to make orders against all of those defendants that are insured if the application is made against them for an order for an interim payment. And that ensures that claimant recovers damages that are required on an interim basis. It ensures that the least injustice possible is done as between the defendants and the claimant. And ultimately, it's in the discretion of the court. So if there are particular features that need to be taken into account, they can be taken into account in the exercise of discretion. My lords, my lady, we see that as a relatively simple interpretation, one that's in accordance with the former rules and one that seems to satisfy the different types of cases that you'll experience in PI cases. And it's not an interpretation that limits the effectiveness of E to that very narrow class of whodunit cases, because it would only be relevant to that. And it would have been much clearer in those circumstances if they said who, as opposed to which.
Well, I think you mean the court cannot determine which one.
Which one, yeah. Which defendant or which one, yeah. That would be clear, wouldn't it? We say it's which defendants judgment would be entered against. I think in Mr Melton's skeleton he used the expression which one or more defendants.
Well, it's just an open question.
Yeah, it's just an open question.
Which of these defendants will the claimant succeed against?
Yes.
Answer, don't know, because it could be one, it could be two, although Mr McLaughlin says it couldn't be two on his own, or it could be one and two. Yeah. Don't know which.
That's precisely our point. I don't know if I can take that point any further.
That's 2A.
Yeah,
we're on to insurance, are we now?
we're on to insurance. Well, D2 and D4 were insured. They're still insured, as far as we know. And isn't that the end of the point? And the insurance covers the risk, and that's the end of it. And it's not sufficient for a party to say, but something might happen in the future, because otherwise they needn't even reserve their rights at this stage. They could just come along to any interim payment application, defendants could, and say, I know I've got an insurer in the background, but between now and the trial, I might do something contrary to the policy of insurance. I might not cooperate and attend trial, and then I'm not going to be insured. And so you shouldn't make an interim payment order against me because of something that may or may not happen in the future. Well, that's nonsense. It's about the state of play as at the day of the hearing, and they were insured then.
What about the point that the policy may not cover for an interim payment? I mean, my immediate reaction to that is, if it's a liability policy, it's going to cover liability to the claimant.
Yeah.
And an interim payment, although it is an interim and potentially temporary, an order for an interim payment creates a liability to the claimant.
It creates a judgment that can
Creates
be
a
enforced
liability.
in a normal way, and a liability, yes. I've seen no evidence put forward as to the basis upon which it could be refused. I accept that D2 has said we're not going to pay, no. But that's not sufficient in my submission. It's just not good enough. Now, you'll be familiar, I'm sure, that the MIB often join themselves into cases where they have a conflict of interest with the uninsured driver they're ostensibly representing. So an insurer faced with an interim payment application who has a real concern, in my submission, could seek to be joined into proceedings to make such representations as they wanted to.
What's the name? What's the name of the case? There was a classic. I'm afraid I've just forgotten. There was a classic case which I think was a decision of Lord Dennings, which established initially that the MIB in
Yes.
such circumstances could, and I just can't remember the name of it.
Yes, forgive me.
But I think the principle is not in doubt.
No.
That if an insurer wished to, or with knowledge of an interim payment application, wished to come along and say this person is not insured, they could apply to be joined.
Yes, they could. And isn't that their remedy?
And, subject to anything Mr McLaughlin may say, I would think that's conventional.
The case is Gertner and Circuit.
Gertner and Circuit, that's it, 1968, something like that.
Oh.
Well, let's
Something like
not play
that.
this game anymore, but anyway, it is definitely Gertner and Circuit.
Yes.
Yeah.
So yes.
And as to what insured means, I mean, it's a perfectly ordinary word,
Yes.
and analogies may not be helpful, but it's, for example, a criminal offence to drive a car without insurance. They're not insured. So one could scarcely see that somebody would be convicted of driving without insurance if they had a policy of insurance which the insurers cavilled at.
Yes, and it's a mandatory requirement to have employer's liability insurance. And this employer did have employer's liability insurance, and they wouldn't have been guilty of offence.
You say that insured means just that you have a policy of insurance.
Yes.
As indeed in the two cases we've just been discussing, is obligatory.
Yes. And the argument comes down to discretion in my submissions. It's as simple as that. We move on very quickly from the insurance point to
So
discretion.
you say they're insured.
They're insured, full stop.
And
Does it cover this risk? If it was an RTA policy and that was the only insurance, then of course it doesn't cover this risk. But the insurance in place that covers this risk, and that's the end of it. And if there's any real argument about them not being insured, then in my submission it's for the insurer to join themselves in and to put evidence before the court to show that the policy's been repudiated or voided, and that voidance or repudiation's effective. Of course, it might not be. They might purport to do that, but it might not be effective.
right, so that also comes in under the discretion issue.
Yes, so let me turn to discretion. The judge has to take into account all sensible matters on the exercise of his discretion, and he's done that.
And the court could order trial of the issue of cover.
Court could, and there was a consideration whether to do that in this very case. But at the late stage it was raised at the hearing without any representations from the insurers. Judge Bird wasn't minded to do that. And he's not criticised today in that respect. It's very difficult to do so. Mr Dignam's not here saying he should have acceded to my suggestion that we defer matters off and get the insurers here and have a mini trial about this.
And you've got a very much lower payment than you had applied for.
So we turn to discretion. The judge has taken all of these matters into account. He's balanced them, and as my lord said, my learned friend has to persuade you that he was bound to refuse the interim payment order in the exercise of his discretion. And in my respectful submission, you can't go so far today. It was a carefully balanced decision with some powerful features on the claimant's side and scant or thin evidence to support the assertions on the defendant's side. And the exercise of discretion in those circumstances was, in my submission, entirely reasonable. Your Honour, the other points that I had noted that I wanted to deal with, if necessary, were in relation to the very point whether all defendants had to be insured, but I don't think that's an argument for today, bearing in mind the concession made by my own friend. Therefore, I don't take that any further. So unless there's any point which you think I am required to deal with, my lord, my lady, then those are my submissions.
Thank you, Mr Lemmy.
I'm very grateful, thank you.
Any reply?
Yes, briefly. Thank you. If a claimant is not entitled to an interim payment against a defendant under subparagraph C, why should the fact another defendant will be liable to the claimant under C, why should that mean that the claimant should therefore be entitled to an interim payment under the first defendant under E? It's not logical in my submission that a defendant who can successfully resist an application under C finds himself having to make a payment under E just because there's another defendant who is liable. I mean, that means that the potentially innocent defendant's position on an interim payment application is dictated by whether there's somebody else in the case. I mean,
That's why you have the protection of subparagraph 2.
Well, that is not an answer in my submission to the point.
I thought it was quite a good answer.
Well, it may well be. Well, that will be for your lordship to decide. You're in the fortunate position of being able to say it.
Why is it not an answer?
Well, because look, the hurdle on an interim payment application under C is quite high. You've got to prove that on balance you will obtain judgment against that individual defendant. If we'd been sued alone in this case, the claimant wouldn't have got an interim payment under C. I don't think there's any suggestion otherwise. If we then move to E, why should our position be any different or weaker just because the claimant happens to have included in the proceedings somebody else who is definitely liable? I'm sorry, but I just don't accept that's logical. Otherwise, why doesn't C could simply have imported an insurance requirement if the answer is, well, you're covered by insurance. I struggle very much with the idea that you can use E somehow to water down the hurdle you've got to reach in pursuing an interim payment where there's more than one defendant. I don't accept it's logical to say, well, the test should be different just because, against any individual defendant, just because there happens to be somebody else involved. In my submission, if and perhaps if I move on to this, I was going to let me deal with the motorway pilot point. Let's suppose we've got A, B, and C as the defendants. A is definitely liable, so an application against under C will succeed against him. Let's suppose B and C, not sure. How do we deal with that? This is the answer. Claimant gets an interim payment against A under C. As far as B and C are concerned, they're dealt with separately. The judge asks, B and C are in E, is the claimant going to succeed against B and C? A is excluded from the class of people he's considering at this stage. He's just looking at B and C. He gives the interim payment against A under C. When it comes, because he can't be satisfied under C against the other two, they go into E. And he asks then, in relation to E, right, is the claimant going to succeed against one of these two? And if so, can I say which one? He ignores A for the purposes of this exercise. That's how you deal with it. You don't stick them all in together and say, well, he's going to succeed against A, and because of that fact alone, B and C have also got to pay up. That is, in my submission, that is wrong. That is the wrong way to approach it. A is in C, and B and C go into E, and you then apply the test that those two, or you then apply E to those two, and you ask yourself, is he going to succeed against these two, and can I determine which one? If the answer is he is going to succeed against these two, then E is engaged. If you can't determine which one, then he is satisfied. If he finds, if for the sake of argument, he's satisfied against A under C, and he's also satisfied against B under C, then we don't get to, he's not sure about the third defendant, then we don't get to E at all. The interim payment's ordered against A under subparagraph C, it's ordered against B under subparagraph C, and the third one, it does not fall within E. That is the way to deal with a multiple pile-up case. E is only concerned with a collective of people who might be liable. It is not concerned with a collective of people who are a mixture of those who are definitely liable and those who might be liable. C is concerned with those people who are definitely liable. E is on an individual basis. You're either definitely liable or you're not, and that dictates whether you have to make a payment under C. E is only concerned with those people who might be liable. In other words, no one in C falls within E. E is those people against whom you're going to get one of them, one of the people in that collective, but you can't say of the individuals in that collective that you're going to succeed against any one of them. That's why in the motorway pilot case, you deal with it in the way I have suggested. Those people who are definitely liable, you get your interim payment under C. Those people who you're not sure about, you put them all in E, and you then ask the question, right, of all of those in E, is he going to succeed definitely against one of them? And that fits. It doesn't make any sense in my submission to say, well, the test should be watered down against a defendant having to make, against whom an application is made, just because there happens to be somebody else who is definitely at fault. That is not fair or just. That's my reply.
Thank you very much. Well, anything else? Well, thank you very much for taking us through this so effectively. Inevitably, we'll take some time to consider what you've said and let you have our decision in due course. You will know that you'll receive draft judgments in confidence for editorial correction and the like, no re-argument. And at that point, could you please provide us with an agreed draft order? If there are any disagreements, we will resolve those on paper, and the judgment will be handed down. Judgments will be handed down in due course, no doubt still by the electronic route without the need for any further attendance. But thank you again. That concludes the hearing.